How long did you work for Senator Cruz?
Senator, I worked for Senator Cruz for 3 years.
Okay. Did you work closely with him?
I would say so, Senator, yes.
Okay. Is it true that Senator Cruz can burp the alphabet backwards?
Senator, I've been instructed not to reveal that.
Is it true that growing up, Senator Cruz had an imaginary friend who his parents actually preferred?
Senator, I have no such knowledge.
Okay. What article of the Constitution calls for checks and balances?
Senator, I think checks and balances is inherent in the first 3 articles of the Constitution, which gives to all of them different powers and responsibilities.
Okay. Mr. Peterson, welcome. Tell me how you amend the U.S. Constitution.
Senator, you amend the U.S. Constitution pursuant to the procedure found in Article 5.
Could you speak into that mic, please, sir?
Sorry, Senator. The Constitution is amended pursuant to the procedure in Article 5, and that is a two-thirds vote of both the House and the Senate, and then ratification by 3/4 of the states. There's also a constitutional convention method, but that's never been used.
Okay. Mr. Fowles, how are you?
I'm doing well.
What's the warrant requirement?
The warrant requirement states that any person who is going to be arrested should have a warrant. The police should seek a warrant for that person to arrest them. There are exceptions to the warrant requirement, including exigent circumstances, which are usually followed up in Arkansas with a probable cause complaint and an affidavit and warrant in support of that.
What about to search someone? Do you have to have a warrant?
Yes, that is.
Let me amend that. Does the warrant requirement apply to search and seizure?
Yes, according to the Fourth Amendment to the United States Constitution, there shall be no unreasonable searches and seizures without a warrant. There are obviously exceptions to that as well, including the Carroll-Ross doctrine for movable objects, exigent circumstances when time simply doesn't permit to be able to seek a warrant from a magistrate or a judge. But yes.
Could Arkansas decide that it doesn't want to follow the federal rule, that it wants to require a warrant for all arrests and all searches and seizures with no exceptions?
They certainly could, Senator. However, as a prosecutor for many years, I understand that those exemptions to the warrant requirement are important for public safety and for law enforcement safety.
How could Arkansas do that?
Arkansas could pass a law with the state legislature to say that a warrant is required for every arrest that's made throughout the state of Arkansas. And obviously, that would be subject to challenges in both state and federal court.
And if Arkansas did that, why doesn't the Supremacy Clause overrule Arkansas?
It certainly would be an argument if that was challenged in federal court.
Well, who would win?
I'm not sure without knowing more facts about how the statute was drafted and being able to examine exactly, the type of legislative interpretation that goes along with that. So without more facts,
let me give you these facts. You recited correctly the warrant requirement and the exceptions both for arrest and search and seizure. Suppose the Arkansas legislature said, we appreciate the advice, but we're not going to follow it. We're going to require a warrant for both arrests and for searches and seizures, okay? And somebody challenged that under the Supremacy Clause. Who would win?
I'm not sure that I've ever thought about that in depth, Senator, but I think it would be a strong challenge to that state law, and I think it would be.
What if Arkansas construed its state constitution to require a warrant for both arrest and search and seizure?
I think it would be the same analysis, whether it was a law that was passed by the state legislature or an amendment to the Constitution.
Why couldn't Arkansas? Have you ever heard of the adequate and independent state ground doctrine?
Yes, Senator.
Why wouldn't the adequate and independent state ground doctrine apply there?
That certainly would be an argument that one of the parties could make in support of that Arkansas state law. And again, I think it would go back to legislative analysis and determining all the factors that go into that as to whether that law would withstand the scrutiny from the court.
Okay, thank you, counselors.
Today on Capitol Hill, a Senate confirmation hearing took an unexpected turn as lawmakers quizzed witnesses on everything from constitutional law to some surprisingly offbeat trivia. The questioning opened with Mr. Ganji, a former staffer to Senator Ted Cruz. After confirming he worked closely with the senator for 3 years, he was pressed on some tongue-in-cheek questions, including whether Senator Cruz could burp the alphabet backwards, or once had an imaginary friend his parents preferred. Ganji, keeping a straight face, declined to answer the first and dismissed the second as something he knew nothing about. The tone shifted when the hearing moved to constitutional fundamentals. Asked which part of the Constitution establishes checks and balances, Ganji noted that the system is embedded across the first 3 articles, which divide power among the branches of government. Next, Mr. Peterson was called to explain how the Constitution is amended. He pointed to Article 5, outlining the process, a 2/3 vote in both the House and Senate, followed by ratification from 3/4 of the states. He also noted the alternative method, a constitutional convention, which has never been used. Then attention turned to Mr. Fauch, who was questioned on the Fourth Amendment and the warrant requirement. He explained that arrests and searches generally require warrants, though there are well-recognized exceptions, such as exigent circumstances or cases involving movable objects. He emphasized that these exceptions are often crucial for public safety and effective law enforcement. The senator then posed a hypothetical. Could a state like Arkansas choose to require warrants for all arrests and searches, with no exceptions? Fauch said the state could pass such a law, though it would likely face legal challenges. When pressed on whether the Supremacy Clause would override such a state rule, he said the outcome would depend on the specifics, but acknowledged it would raise significant constitutional conflict. The questioning then moved to whether Arkansas could interpret its own constitution to impose stricter warrant requirements. Fauch noted that the same legal analysis would apply, but acknowledged that the adequate and independent state grounds doctrine might become part of the argument. In the end, the witness reiterated that while states can set higher standards than the federal baseline, those standards must still withstand potential challenges under federal constitutional authority. The hearing concluded with the senator thanking the panel of counselors for their testimony.